Good morning.
Morning.
I don't guess I need to save time for rebuttal this morning.
Unless you want to rebut yourself.
I don't
which
think I
would be
will, as that would be odd. But anyway. May it please the court, I'm Keith Hobson. I'm here on behalf of the appellants in this case. This case involves an amended petition to terminate parental rights that was filed by my clients, the appellants. The trial court dismissed the amended petition to terminate parental rights, ruling that termination was not in the best interest of the minor child. The case came up on appeal, was remanded back to the trial court because the trial court did not use the appropriate best interest factors in the initial hearing in January of 2022. On remand, the trial court considered the appropriate best interest factors and found that termination was still not in the best interest of the minor child, considering the new factors. I would submit on behalf of the appellants that ruling of the trial court should be reversed. And I just want to go back just a little bit just to the background of the case.
Your clients are the grandparents, is that correct?
Excuse me?
Your clients are the grandparents, is that correct?
The grandparents, they're the paternal grandparents, yes, sir. This case involves a child, Liberty T. She was born on June 10 of 2018. She's currently 6 years old. The child was born in Pennsylvania. The parents moved to Tennessee about a month after she was born. When they moved back to Tennessee, they moved in with the paternal grandparents, Mr. and Ms. Tate. And like I said, that was in July of 2018. The child has been with the paternal grandparents since July of 2018. The child, when the parents moved to Tennessee from Pennsylvania, they lived with the paternal grandparents for a short period of time. So the mother, which really is the focus of this appeal, has never had the child in her home on a permanent basis. She's had the child in her home for visitation, primarily supervised, but there was a period of time, which I'll get into, when the visitation between the mother and the minor child was unsupervised. This case got started in September of 2018 when DCS filed a petition in the Hawkins County Juvenile Court alleging that the child had been exposed to drugs. The DCS investigation revealed concerns of domestic violence between the mother and the father, and also a need for mental health treatment for the mother. And that was based on a statement that she had made as far as suffering from bipolar disorder and also anxiety. So that was of great concern to the state. Thereafter, an order was filed in February the 26th of 2019, adjudicating the child to be dependent neglected. Pursuant to that order that was filed in February of 2019, each parent was required to complete certain responsibilities to become eligible to regain custody. One was to obtain and maintain stable and safe housing. The second was to follow recommendations from a clinical parenting assessment. And the order from February of 2019 states clearly that both parents they understood what those recommendations were. As a matter of fact, that assessment is in the court, in the record, is Exhibit 3 in the record. The juvenile court, I'm sure the court's familiar with CASA, but appointed a CASA representative by the name of Tracy Burke in October of 2019, kind of investigate the situation. Ms. Burke, at the trial in January of 2022, testified about 2 visits that she made to the mother's home. One in January of 2020, the other in February of 2020. The first visit in January is January the 7th of 2020. She went to the home. The child was not there. It was like a Tuesday afternoon. And she went there primarily to test the mother's boyfriend for drugs. That had been an issue. She went, tested the boyfriend, he tested positive for THC. She went into the house, it was cluttered, these are her words, it was cluttered and unkept. She was concerned about the state of the mother's bedroom as it contained old food, children's milk containers that were so old that the milk had separated. She, after that, about 30 days later, she returns to the mother's apartment. And this was an unannounced visit. And this is a very important visit because it was on a Saturday. And at that time, mother had unsupervised visitation with this minor child. So when she made this unannounced visit, she found, once again, the apartment was dirty and disarray. And she found it very concerning that during this visit, she found an ottoman in the living room that was being used as a coffee table. And the ottoman had a picture frame that was turned upside down on it so they could use it as a solid surface. And on that solid surface of the picture frame that was on the ottoman was a white powdery substance that was on the picture. She testified that at that time when she found that the child was inside of the apartment and that the child could have reached this white powdery substance. She also testified there were ashtrays, lighters, an iPod earbud case with a marijuana roach in it. And her testimony was that the apartment did not appear safe for the child, and she had some very serious concerns about the apartment. Thereafter, the guardian ad litem, Deborah Yeomans Barton, she made an emergency phone call to the court, to the juvenile court judge. And the juvenile court judge entered an ex parte order requiring that her mother's visitation be supervised. Ms. Burke, there was an upcoming case in juvenile court. There have been some allegations that the petition filed by the appellants to terminate parental rights was because of this upcoming court case. The primary reason for the filing of the petition was what happened in January and February. There were great concerns about that. Ms. Burke, after this ex parte order went down in February of 2020, filed a report that was dated March 5 of 2020. And in that report indicated that the mother exhibits a high level of immaturity, impulsivity, and poor decision making. And in the summary of that report from March 5 of 2020, she stated that the mother does not exhibit the ability to care for the child on a daily basis. Subsequent to that, the petition was filed, and that was April 23 of 2020. On August 6, 2021, the amended petition to terminate parental rights was filed, and the hearing was January the 10th of 2022. Of course, at that hearing in January of 2022, the court used the incorrect best interest factors, but found that the termination was not in the best interest of the minor child. Of course, the case was remanded back, and the court reviewed the facts with the new factors, the applicable factors, and made findings of fact based on these new factors. And I'd like to just go through those. As far as A, the effect a termination of parental rights will have on the child's critical need for stability and continuity of placement throughout the child's minority. The court, in its initial ruling, discussed stability and sometimes how the factors may not be weighed exactly the same. Some may be more critical or weighed more favorably than others, and made a real point in that initial ruling that stability was something that was very important to the court as far as consideration. In subsection A, the trial court found that the mother deserves a chance and that this factor under the circumstances does not weigh in favor of termination. As I stated, the trial court stated that this was similar to the old factor number 5. And as I stated, the trial court, its ruling on January 10 of 2022, stated that the court heard about the substantial relationship the child had with the petitioner grandmother, the grandfather, and also another child of the appellants. Her name's Brittany. That's the minor child's aunt. And they just have a very substantial relationship, very close, loving relationship. As a matter of fact, there's a picture in the record, it's Exhibit 8, that shows Brittany, the aunt, holding the child. The picture's dated July 18 of 2018. The child's 5 weeks old. And that picture just tells the story of the relationship and the love that you can see Brittany showing this little girl. And she's been with her ever since she's been back in July of 2018. As I stated, as far as factor A, the trial court in its January 10 ruling, 2022 ruling, stated that this was extremely persuasive to the court in favor of termination. And then in considering the factors based on after the remand, says that does not weigh in favor of termination to such a degree that termination is mandated. As far as factor C, the trial court stated at the time of the initial hearing that mother had made such great progress that the factor no longer weighs in favor of termination. And that states whether the parents demonstrated continuity and stability in meeting the child's basic material, educational, housing, and safety needs. As I stated earlier, the appellants presented evidence through CASA, through their worker, Tracy Burke, that she had not met and had not demonstrated stability in meeting the child's basic housing and safety needs. At the hearing in January of 2022, the mother offered absolutely no proof, no evidence as far as her current housing situation. And the guardian ad litem had not even visited the mother's home at the time of that hearing. As far as D, the trial court found that the mother and child do not have a mother-child relationship that is more like a friend or a sister relationship. The trial court found that this factor weighs against termination, and that is whether a parent and child have a secure and healthy parental relationship. The trial court made a finding that they have a sister and a friend relationship. There's no mother-child relationship. As far as subsection E, as far as maintaining regular visitation, at the hearing in January of 2022, the proof was that she was very sporadic in her visits. And then after the case was remanded, we went back before the court, and there's an order from that August hearing in 2023. The mother still hadn't visited. There were 3-month periods between the time that she would visit the child. So the court states that this factor weighs against termination. The parent has not maintained regular visitation. It definitely weighs for termination. As far as F, whether the child is fearful of living in the parent's home, she's never lived in the parent's home. As far as G, I think it's not applicable since the child's never lived in the mother's home. I discusses whether the child has emotionally significant relationship with persons other than the parents and the caregivers. I already mentioned Brittany, the aunt, who she has a very close relationship to. As far as K, which is surprising to me that the court would find that this factor weighs against termination, in that in the order filed February the 26th of 2019 that adjudicated the child dependency and neglected, the mother was required to follow certain recommendations stemming from this assessment for her to regain custody of the child. It recommended that the mother participate in individual therapy. She testified at the hearing that she but she had numerous no-shows to the Kingsport Frontier Health Office. Kingsport office closed her case. The assessment recommended that the mother participate in family therapy. Mother testified that she did not go through family therapy as recommended. The assessment requested medication management for the mother to monitor her medications. The mother testified she did not go through the medication management program. And also the assessment recommended that mother attend parenting skills training, which she did not do. She testified that she did not complete the parenting skills training. So as far as that Section K, the mother did not take advantage of any programs. They were laid out in an assessment. And her testimony at court was she did not go through those programs. There was no evidence presented by mother at the trial that she did. I'm about out of time. And then as far as M, she's demonstrated no sense of urgency in addressing the circumstances that made an award of custody unsafe. She had a year. She had from February the 26th of 2019 until the February date in 2020 when the CASA worker came to her home. Her home was not safe. I think a year is enough time for her to get that together. She did not. And I feel like that in this case, it is in the best interest of the minor child that the mother's rights be terminated and that the trial court decision be reversed.
You're basically saying that the trial court made inconsistent rulings each time. The
Yes.
initial ruling and when it went back, the trial court
I don't mean
went
to
back
cut
on
you
its
off.
ruling.
Yes, I do. Like I was talking about with the old factor 5. I don't understand the inconsistency. And it was something that was really obvious. And because like I said, it was so strong in the judge's ruling from the January 2022 hearing that the stability factor was very, very important. It should be weighed heavily. And then when we go back, that same factor, he finds that it doesn't favor termination.
Okay. Thank you very much. Your
Thank
time
you.
is over. This case has been submitted to this court for resolution. You should receive our ruling within a reasonable period of time.
Thank you. Thank you for your attention today.
Thank you.
Thank you.
And if there's nothing further, you may be excused. Thank you, Trooper.